It's me! Sorry I'm not there for you. And I will be there in just a few minutes, but I thought that I would give you this little lecture for something to do while I am unavoidably delayed for about 30 minutes tonight. So what I'd like to do is just give you the lecture on employment at will, and then we'll go over this in class as well as go over some cases. So I'm doing this on one take, so please forgive me. So employment at will is a really important chapter in school, in this class, because it is the foundation from which everything lifts off from. And you hear a lot about discrimination and how wrong it is, and it is. But the fact is, employment at will as a policy is very strong in this country for reasons that we will discuss and have discussed already. So let me talk about employment at will and talk about the exceptions to it, and then we'll go from there. So first of all, in spite of the rising number of workplace regulations, employment at will remains the dominant, strongest employment policy in the United States. And what that means is, employment at will, is that either the employer can fire you at any time for any reasons except for one of the exceptions, or the employee can leave at any time for any reasons, period, unless they have a contract. So we'll talk about that in a bit. But generally speaking, roughly 65% to 70% of all employees in the United States are under employment at will. There are some exceptions to it, such as a violation of a public policy, or one of the exceptions is breach or exists. And in that case, then you have what's called a wrongful discharge or an unjust dismissal. And the employer could be liable for damages inflicted on the terminated employee. Again, we'll talk about that in a bit. Now, for there to be an employment contract, and therefore outside the employment at will, there needs to be a few things. First of all, an employment contract can exist without anything in writing. So let's get that clear. That's called an implied contract. But there must be, for a contract to exist, a meeting of the minds, an agreement or a mutual understanding of what the key terms of the relationship are. Key terms in an employment contract generally include pay, hours of work, location of work, length of service, etc. But there can be other items. So you look for details that indicate that the two parties have an understanding of the details of the job, pay, length, duties, and therefore they had an understanding or a meeting of the minds, and therefore what's called a contract about that employment. Finally, there has to be something called consideration, which means one party was given something has given up something in order to enter into the contract. We'll talk about that more. One topic included in many employment contracts, I'm just going over a few highlights here, something called the non-compete clause. Now, non-compete clause means that if you leave your employer, you cannot go into the same industry and compete against them. Now, the courts will look closely at non-compete clause for obvious reasons. They don't want to put people out of work and put them in the unemployment lines. So what will court look to? The reasonableness of the non-compete clause. For example, it has to be reasonable in terms of industries that it covers, and it has to be reasonable in terms of the geography it covers. A lifetime salesman who enters into a non-compete clause with an employer will not have, and then leaves, will not be held responsible or to that non-compete clause if it's the non-compete clause says that the employee cannot sell anything for, say, 5 years. That's just too broad and too devastating for the employee. So what would be a more reasonable and enforceable non-compete clause might be something that says the employee cannot sell in the, say, software market in the Washington, D.C. metropolitan area for the period of 1 year. That's much more reasonable and more likely to be enforced. Okay, so employment at will. Just a little bit of the background. Employment at will came about because U.S. law is based on English law primarily and something called Anglo-Saxon traditions. And in the Anglo-Saxon tradition and English law, there was something feudalism. English feudalism exists. In that case, in feudalism, back when they had castles and whatnot, the employees, or what were the employees, actually lived on the employer's property. And the employer provided housing, provided food, provided what education they had, and they provided work. And the laws at that time for feeling the best for society was the employer should have duties to take care of the employee. So that preceded that concept where the employer fed the employee, housed the employee, gave them work, took care of their education, preceded employment at will. As society evolved and we moved toward the industrial revolution, employers needed more employees, and the employees were able to leave the castle, if you will, or essentially a plantation, if you will, and get job on a regular basis. So that was the beginning of employment at will. Employees wanting to move off the plantation, essentially, and employers needing more than just employees that worked on their property. So gradually, and I'm covering a lot of time, employee rights began to develop to where we are now, where the standard rule is employment at will. However, there are a number of exceptions. The big landmark case or evolution was in the United States was the Civil Rights Act of 1964. In that, there was a section called Title VII, and employment law is often referred to as Title VII. And what they mean by that is that the civil rights law made it illegal for employers to make decisions based on race, gender, nationality, religion, things of that sort. But even with Title VII, employees could still be fired for any reason except the protected categories. For those not protected, there are a few rights due to employment at will doctrine. And just to be clear, protected categories under Title VII: race, gender, color, national origin, religion. So what we have right now, employment at will doctrine exists, can be fired anytime, can quit anytime, cannot be fired due to one of the protected categories: race, gender, religion, national origin, color, and then you add to that subsequent laws: age and disability. Okay, those are sort of the categorical or statutory exceptions to employment at will. Now there's three others that are particularly important. The book talks a little bit about the Worker Adjustment and Retraining Notification, or WARN Act. I'm not going to deal with that. It's not used very much anymore, and I don't want to spend time on that act. I do wish to spend time on public policy, implied contract, and constructive discharge. Okay, so public policy exception to the Employment at Will Act. Sometimes employers ask employees to do illegal things or unethical things. An example of that might be to avoid jury duty. Could be to violate the Clean Water Act, or participate in price fixing. Or the employer may ask the employee to avoid taking some activity like joining a union, which is a statutorily protected right to do. Now, I know labor law applies in that area, but it's just an example. So, when there is a public policy that the employer is asking the employee to violate, that employee may be protected from an employment at will termination or to unjust dismissal. How do you know when you have a public policy? Public policy is often defined by statute or by the Constitution, so it's a law. Um, Now, society's interests are defined by law, and for the law to rise to the level of a public policy exception, the law violated must be quite substantial. It must affect citizens, not just one citizen, but citizens of the state collectively. And it must have been a policy at the time of the termination. So courts will look to state law or federal law, constitutions, state or federal constitutions, to see if there is some policy that the employee was trying to perform, jury duty, for example, that the employer was prohibiting them from performing and therefore fired them. So, generally, public policy exception is upheld when it falls into one of three categories: refusing to break a law, price fixing as an example, performing a legal obligation, jury duty, or exercising a legal right such as forming a union. So why are those particular laws more important than, say, another dog bites man law, or man dog, is because price fixing, for example, would be a very serious violation that would impact a lot of people. Jury duty. What would happen to society and the judicial system in particular if we couldn't get citizens to serve on a jury? So it's those types of laws that are more likely to be found as violations of the public policy exception. Again, employment at will is a strong doctrine. Courts don't like to overrule it, but they will on a public policy exception. The next act is something called the breach of next exception is something called the breach of implied covenant of good faith and fair dealing. Every contract has an implied covenant that neither party will do anything that will destroy the right of the other party to receive or enjoy the benefits of that contract. This exception gives the parties more incentive or confidence that the contract will be executed by both parties, or the employment agreement will be. And this exception exists only in a small number of states, so it's not something that's heard of very often. In looking to see if the implied covenant of good faith and fair dealing applies in an employment situation, courts will look to the action of the parties. Did they say or do anything that said, we want to have a contract, and then pull back from it after the other party acted? Okay, the next exception is very similar to implied covenant and good faith and fair dealing. It's called the implied contract. And what that means is the courts will find a contract exists even if nothing is in writing when, number one, they look at this, the facts of the case, and say, wow, somebody just got the shaft here, usually the employee. Just a bad deal toward the employee. And also, if they can look at the arrangement for employment and see that the parties had a meeting of the mind. They came to terms on the basic terms of the contract, if you will. And what are the basic terms of an employment contract? Pay, duties, length and location of service, and things of that sort. So, courts will sometimes find an agreement where there was no written contract. When the court finds a clear injustice is done, they will look to acts and words of the parties to determine if a clear agreement existed, and therefore they can construct or imply a contract existed between the two parties. Now, the last element that I mentioned earlier, and I'll mention again, there must be something in the contract called consideration. Consideration is a requirement for any enforceable contract, whether it's an employment situation or otherwise. Consideration is the bargain for elements that motivates parties to enter a contract. It is any act or promise of benefit to one party or disadvantage to the other, such as moving the family, selling your house, or turning down another job. So a written contract does not have to exist. Courts will look at the conduct in written materials such as employment manuals. We had a case like that, given to the employee by the employer. The statements made by the employer at the pre-employment interview could also be a source of the terms and details of the contract. Let's talk about employee policy manuals for a second. These can unwittingly, for the employer, create an employment contract when courts find that they created an implied contract. The key to determining if an implied contract was created is whether a reasonable employee reading the handbook would believe that they had been guaranteed certain protections. Terms in the manual may say something like terminate only for good cause. That means you can't be fired at will. Or your employment continues upon successful completion of probation creates a permanent employment. I didn't say that very well. There could be a clause in the employment manual that says once the employee passes a probationary period, they become a quote-unquote permanent employee. A permanent employee is not an employment at will situation. The employer can avoid creating confusion around employee manuals creating a contract or statements made in an interview creating a contract by avoiding creating a reasonable belief that a contract exists, and by very prominently and clearly and demonstrating that the manual does not create an employment contract. And we'll talk about it. We'll look at some cases related to that. Now the last item is called constructive discharge. That's when the employee simply quits because work basically sucked so much that they couldn't, no reasonable person would be expected to perform under those conditions. So if an employee walks off the job because the employer wanted them to work 72 hours straight, wanted them to work at very high elevation, and it was not under unsafe conditions, or the employer refused to pay, something about the terms and conditions of employment were so difficult that a reasonable person would say, I can't do this, I have to get out. It occurs when the employer makes conditions so intolerable no employee should reasonably be expected to endure them. Employees, in many instances, employees must show that the employer's actions were motivated by bad faith, malice, or retaliation. So you can point to something like, I told the boss that my supervisor was watching the NCAA games instead of working. So the supervisor gave me, the graveyard shift for 10 consecutive days. That might be an act of retaliation or malice toward the employee. Okay. The book spends a lot of time on something called torts. Tort is a French pastry. It's also a term of art in law referring to personal injury. There are some tort liabilities that the courts will recognize, but generally personal injury cases are not handled in an employment law context. They're handled in a personal injury context or a tort law. But worth mentioning, I feel, because they do pop up sometimes in employment law cases, is A, when the termination happens because of intentional outrageous conduct by the employer causing emotional distress to the employee may have what's called a wrongful discharge due to tort. That's recognized in 25 states, and we'll talk about some in class. Defamation. Employee can sue the employer, can quit, sue the employer, and get compensation or even their job back if the employer made a false and defamatory statement about the employee, communicated that statement to a third party without the employee's consent, and that statement caused harm to the employee. The last item is invasion of privacy. If somehow the employer invaded the privacy of the employee could claim emotional harm, be fired, and either get their job back or get compensation. The reason I don't really talk about torts a lot is because they don't lead to being reinstated very often. Usually they damage the relationship so bad that the existence of the personal injury may be part of the unjust termination or dismissal, but they only lead to a larger compensation package. They do not lead to getting your job back. Now, one other issue that is important to this class in this area and UMUC in general is the Uniformed Services Employment and Reemployment Acts, USERRA. Workers who enter military service and receive an honorable discharge are guaranteed reemployment protection against discrimination based on their service. To be eligible for that protection, the employee must provide notice to the employer of his intent to return, unless, of course, military service prohibits providing a notice of intent to return. And second, the employee cannot be gone from the job for more than 5 years. The employee is allowed to return to a position left or a similar position unless the employer eliminated the position as part of a reduction in force or rehiring creates undue hardship on the employer. We'll get into what undue hardship is later on in the semester. So that's essentially the key elements of employment at will. I want to repeat them because this is a very important chapter in the book. It is the basis of the law for which 65% of our employees in the United States toil. Unless you can construct some rationale or exception to employment at will, the employer can fire an employee and the employee can leave for any reason. The key to knowing if that's called employment at will, the key to knowing if your employment at will is there an employment contract or a union collecting bargaining agreement, or if you're in the government, you would have civil service. Civil service rules effectively are an employment contract. So if you signed an agreement, that's an employment contract, you're not in employment at will. If you're part of a union, you're in a collective bargaining situation, not employment at will. Or if you're in the government, civil service, you're not employment at will. Otherwise, you fall under the employment at will doctrine. Leave anytime you want, employer can fire anytime you want, except for the exceptions we ironed out, we talked about. Okay, so we're going to talk about the Title VII exceptions through the rest of this semester. So I just want to reiterate 3 non-statutory exceptions to the employment at will that are very important. One is the implied contract. Look at any conversation or document, such as an employee manual the employer gave out to see if there's substantial evidence of an agreement. Terms on time, specific acts to be performed, specific pay. Was there consideration? Did one of the parties begin to act on the contract? For example, did the employee turn down another job? Did the employee quit a previous job? Did an employee move or sell their house? Something to show that they have begun the process of being employed, of accepting the terms of that agreement. When the court sees that kind of bad behavior by the employer toward the employee, or one of the parties getting the shaft, they will step in and say, look, I'm going to try to create a contract here. Okay. Next exception is the public policy. To apply, the rule in question must be both clear and have a potential impact on society as a whole. Best examples are environmental laws, jury duty. You have to consider if there's an impact on society on the whole, not just the individual. But the informing, and you have to inform the employee, the authorities or police of the violation. It cannot just be a disclosure to the media. I'm not sure I mentioned that earlier. This is not, the public policy exception is not as easy a claim as you might think. The next exception is the implied covenant of good faith and fair dealing. With public policy, courts look to the law to see how important the law is. With this exception, implied covenant of good faith and fair dealing, the courts will look to the parties for intent. Did they specifically say this is employment of will? If no, then some courts will find that an employment agreement has inherently been created because there's a promise to let the parties perform and they must be allowed to perform. Again, implied covenant only exists in 11 of the 50 states. It's not very common. Some of the reason is because it's very close to the implied contract. Last is constructive discharge. That occurs when the employer makes working conditions so intolerable that no employee should reasonably be expected to endure them. All right, that's employment of will. I'll see you in class.